Good day, esteemed viewers. My name is Favour Abolaji, a law graduate of Olabisi Onabanjo University and a graduate intern at HARLEM Solicitors. Today, I'll be taking you on a short but insightful journey into the concept of interconnection of telecommunication networks. By way of introduction, what is interconnection? Section 157 of the Nigerian Communications Act 2003, which is the principal legislation on the activities of telecommunications in Nigeria, defines interconnection as a physical and logical linking and connection of communication systems used or operated by the same or different licensees to convey message to and from respective systems for the provision of services. Now, the various rules and guidelines regulating the activities of interconnection in Nigeria are provided for by the Nigerian Communications Act 2003 and the subsidiary legislations enacted by the Nigerian Communications Commission. These subsidiary legislations are the Telecommunication Network Interconnection Regulation of 2007, the guidelines for the procedure for granting approval, guidelines on the procedure for granting approval to disconnect telecommunications operators 2012, the guidelines on technical standards for interconnectivity of network, and the guidelines for international gateway access and voice over internet protocol. Section 96 to 100 make provisions for interconnection. Section 96 makes it obligatory for every telecommunication network to interconnect. Regulation 1 of the Telecommunication Network Interconnection Regulation states that of 2007 states that where a requested party receives a written request by a requesting party for interconnection, such requested party is obligated to grant such request. In an interconnection agreement, we have the requested party and the requesting party as stated earlier. Simply put, a requested party is a party to whom interconnection request is being made, and a requesting party is a party making request for interconnection. Now, upon receipt of a written request by the requested party, it is obligated to interconnect with a requesting party as stipulated in the Telecommunications Network Interconnection Regulation of 2007 and the Nigerian Communications Act of 2003. Now, it is important to note that interconnection agreements are based on the principles of neutrality, transparency, fair competition, universal coverage, equality of access, among others. Now, there are certain circumstances where the Nigerian Communications Commission would not allow a party to interconnect with another party. These circumstances can be broken down into these three. Number one, where interconnection is prohibited by law. Number two, where there is no point of interconnection. And number three, where the license granted to an operator does not authorize the services or the activities for which interconnection is requested or required. Now, at this point, it is important to state the benefits embedded in interconnection. There are certain benefits or advantages that are embedded in interconnection. They are: number one, to provide services that will not be economically feasible without interconnection. For example, an MTN subscriber is only able to place a call through to a Glo subscriber because of the interconnection between MTN Telecommunication Network and Glo Telecommunication Network. Number two, it increases profitability. Number three, it improves or expands services that are valuable to customers. Number four, it ensures fair competition and efficient use of telecommunication facilities. And number five, it facilitates sufficient capacity and services quality and protects non-discriminatory access. Now, I'll be talking about disconnection or termination of interconnection. The strict rule is that interconnection cannot be disconnection of interconnection is not possible. That means that once two parties are interconnected, once telecommunication networks are interconnected, they cannot be disconnected. However, the law provides for situations where disconnection of interconnection is possible. In the guidelines on the procedure for granting approval to disconnect telecommunication operators of 2012, certain circumstances where a party or a telecommunication operator may bring an application for disconnection of interconnection are stated, and they are: number one, where interconnection debt is due and has remained unpaid. Number two, where there has been a fundamental breach of interconnection agreement. Number three, where interconnection agreement has been terminated. Number four, for any other reason as provided for by the Nigerian Communications Act 2003, any subsidiary legislation enacted by the Nigerian Communications Commission. Now, In the matter of Intercellular Nigeria PLC and MTN Communications Nigeria Limited, Intercellular Nigeria PLC brought a matter before the Nigerian Communications Commission that MTN had unilaterally disconnected Intercellular from its operations. And in Section 100 of the Nigerian Communications Act 2003, there cannot be disconnection without getting prior approval of the Nigerian Communications Commission. In this matter, MTN unilaterally disconnected Intercellular from its operations without getting prior approval of the Nigerian Communications Commission. The Nigerian Communications Commission pursuant to the provision of Section 73, giving it the power to resolve disputes, launched an investigation into this matter and found that Intercellular had indeed been disconnected from MTN's network unilaterally, and that it had fallen short of payment of interconnection debt, and that it had a habit of not paying interconnection charges and rates as and when due. The Nigerian Communications Commission, pursuant to the powers given to it by Section 73 to resolve disputes, decided in that matter that Intercellular should pay up its debt to MTN, and MTN should reconnect Intercellular back to its operation. Now we're talking about resolution of interconnection disputes. The Nigerian Communications Commission is the body charged with the power to resolve disputes arising from telecommunication activities. The Nigerian Communications Commission in Section 73 to 75, also in Section 105 of the Nigerian Communications Act, has the power to resolve disputes using alternative dispute resolution methods such as arbitration, negotiation, conciliation, mediation. For more on Nigerian Telecommunications law, for more information on Nigerian Telecommunications law, kindly visit our website at www.harlemsolicitors.com and follow our social media pages at Harlem Solicitors. Thank you.